Illinois versus Florida. Where to file for divorce. Choosing where to file for divorce can change your financial future and your relationship with your children. If you have ties to both Illinois and Florida, the differences in divorce law can dramatically impact your outcome. A divorce lawyer must first determine which state has jurisdiction to dissolve the marriage and decide custody. Illinois requires that one spouse reside in the state for 90 days before a final judgment can be entered under 750 ILCS 401(a). Florida requires one spouse to reside in the state for 6 months before filing under Section 61.021, Florida Statutes. This difference alone can determine how quickly a case may proceed. Illinois follows an equitable distribution system that divides marital property in just proportions rather than strict equality under 750 ILCS 5/500(d). Florida begins with the premise that marital assets should be divided equally under Section 61.075(1), Florida Statutes. Marital property generally includes assets acquired during the marriage. In Florida, the cutoff date for identifying marital assets is the date the petition for dissolution is filed under Section 61.075(1). In Illinois, property acquired before the final judgment of dissolution is presumed marital under 750 ILCS 5/500(b). That means future earnings may be treated differently depending on where you file. Dissipation of assets is also treated differently in each state. Florida permits unequal distribution for intentional dissipation within 2 years prior to filing under Section 61.075(1)(i). Illinois allows courts to consider dissipation and shifts the burden of proof once a prima facie case is made under 750 ILCS 5/500(d)(2). Business owners face important distinctions between the two states. Florida law excludes personal goodwill from marital assets under Section 61.075(6)(a)(1). Illinois treats professional goodwill under common law principles and may appoint its own financial expert under 750 ILCS 5/500(l). Alimony is another major difference. Illinois uses a structured guideline formula for maintenance based on percentages of net income under 750 ILCS 5/500(b)(1). Florida abolished permanent alimony and now provides bridge the gap, rehabilitative, durational, and temporary alimony under Section 61.08, Florida Statutes. Durational alimony in Florida may not exceed specific percentages of the length of the marriage under Section 61.088(a). Florida also allows modification or termination of alimony upon retirement under Section 61.143(c). Child custody jurisdiction in both states is governed by the Uniform Child Custody Jurisdiction and Enforcement Act. The child's home state, typically defined by 6 months of residence, determines which state can make the initial custody determination. Florida law creates a rebuttable presumption that equal time sharing is in the best interests of the child under Section 61.132(c). Illinois applies a best interest standard without a presumption of equal parenting time under 750 ILCS 5/600(3)(10). Child support calculations also differ between the states. Florida uses a guideline chart and applies additional percentages for combined incomes above $10,000 per month. Illinois uses an income shares model under 750 ILCS 5/500(5). Illinois may require parents to contribute to college expenses under 750 ILCS 5/513(a). Florida courts may not order post-majority college support absent agreement. Personal jurisdiction must also exist for a court's order to bind a spouse. Illinois and Florida both have long-arm statutes that define when a court may exercise authority over a non-resident spouse. Forum non-conveniens may allow transfer of a case when another state is more appropriate, but courts strongly favor the filing spouse's chosen forum. The decision of where to file is strategic and must be aligned with your financial goals, parenting concerns, and long-term plans. An experienced lawyer can analyze how each statutory framework applies to your specific circumstances. A knowledgeable attorney can evaluate jurisdiction, asset division, alimony exposure, and custody implications before you file. Every divorce presents unique facts that require careful comparison of Illinois and Florida law. The law office of Russell Knight is a law firm that helps clients evaluate whether Illinois or Florida is the better jurisdiction for their divorce. The law office of Russell Knight, located at 1415 Panther Lane, number 218, Naples, Florida, 34109, United States, provides strategic legal guidance based strictly on the statutory differences between the two states and can be reached at 239-202-0455.